Good morning. Welcome to the Supreme Court of the United Kingdom. This morning we are hearing the appeal in A and B against the Criminal Injuries Compensation. The hearing is taking place online because of the current pandemic. There are reporting restrictions in this case. The court has ordered that no one shall publish or reveal the names or addresses of the appellants, who are the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of the appellants or of any member of their family in connection with these proceedings. The issue in this appeal is whether excluding A and B, who are victims of human trafficking, from compensation under the Criminal Injuries Compensation Scheme unjustifiably discriminates against them in breach of Article 14, taken in conjunction with Article 4 of the European Convention on Rights. I'm Lord Lloyd Jones. I'm sitting today with Lady Arden, Lord Hamblin, Lord Burrows.
Good morning.
And Lord Stevens. The appellants, A and B, are represented by Philippa Kaufman, Queen's Counsel, and Shu-Shin Liu. The respondents, the Criminal Injuries Compensation Board, are represented by Ben Collins, Queen's Counsel, and Robert Moretto. We have also received written submissions from Karen Monaghan, Queen's Counsel, James Robotham, and Admas Habteslazi on behalf of the Anti-Trafficking and Labour Exploitation Unit. They are interveners in writing only. Today is the 11th of November. At 11 o'clock, we will be observing 2 minutes silence as an act of remembrance. I will indicate when we reach 11 o'clock, and I will indicate again when the 2 minutes silence has ended. Thank you. Ms. Kaufman.
Good morning, my lords and my lady. My Lord Lloyd Jones has set out the issues in this case, and by way of introduction, A and B fell foul of the scheme because they fell within the operation of paragraph 3 of Annex D, which precludes any applicant who has an unspent conviction for the offences that are specified in that paragraph from making an application under the scheme. Those sentences that they were subject to were sentences that they had received before they came to England, and they were custodial sentences. And as we will see later when we look at the scheme, custodial sentences that are unspent are caught by paragraph 3D. Once they'd served those sentences, they were trafficked to the United Kingdom, where they were subjected to forced labour. And the details of that forced labour are set out in our case. I'm not going to take your lordships and my lady to that. Paragraphs 8 and 9 of our case, electric bundle number 59. Suffice to say, they gave evidence at the criminal trial of their traffickers, who were then convicted under the Modern Slavery Act 2015 of offences of involving or subjecting the applicants to labour exploitation and slavery-like conditions. Were it not for the application of paragraph 3, Annex D, they would otherwise fall or meet the conditions for making an application under the Criminal Injuries Compensation Scheme. The case prepared by the appellant sets out in detail the history of the scheme. That's at paragraphs 13 to 23, electronic bundle 60 to 63. I'm not going to go through that in detail either, just to say that there were 3 iterations of the scheme which were purely administrative. And the first was put in place in 1964, and the first statutory scheme was put in place under the Criminal Injuries Compensation Act 1995, which entered into which followed the enactment and provision for a statutory scheme, followed the entry into force in the United Kingdom of the European Compensation Convention. I could briefly take the court to that. That is in the Other Authorities, tab 18, page 987. And Article 2, which is at page, that's at page 987, the actual, the convention itself, it starts at 987. At the bottom of that page is Article 2. When compensation is not fully available from other sources, the state shall contribute to compensate A, those who have sustained serious bodily injury or impairment of health directly attributable to an intentional crime of violence. And that's paragraph 8 on page 988. There is provision for the circumstances in which an award can be reduced or refused. Paragraph 8.1, compensation may be reduced or refused on account of the victim's or the applicant's conduct before, during, or after the crime, or in relation to the injury or death. And then there are other provisions for reductions, but they are not relevant for our purposes. So, as I said, the Criminal Injuries Compensation Act was then introduced in 1995. And if the court can move back in the bundle to page 478, tab 1 of the principal authorities, section 1 of that enactment is at page 478, is entitled the Criminal Injuries Compensation Scheme, and subparagraph 1, or subsection 1 rather, the Secretary of State shall make arrangements for the payment of compensation to or in respect of persons who have sustained one or more criminal injuries. Subsection 2, any such arrangements shall include the making of a scheme providing in particular for the circumstances in which awards may be made and the categories of persons to whom awards may be made. And that scheme by subsection 3 shall be known as the Criminal Injuries Compensation Scheme. Moving on to section 3, page 480, entitled Claims and Awards. And if your lordships can just read subsection 1A through to F. And again, that makes provision for awards to be withheld or reduced, subject to conditions and other restrictions on the payment of awards are specified. And then at F in particular, there is provision for the imposition of time limits. And finally, in relation to the 95 Act, if your lordships can, and my lady can turn to page 492, section 11, parliamentary control. Before making the scheme under subsection 1, the Secretary of State shall lay a draft of it before Parliament. And of subsection 2, the Secretary of State shall not make the scheme unless the draft has been approved by a resolution of Parliament. In subsection 6, whenever any other provision of the scheme is altered, the Secretary of State shall lay a statement of the altered provision before Parliament. All the iterations of the scheme before the 2012 scheme was introduced, and it's the 2012 scheme with which we're concerned, included a discretion to reduce or withhold payments under the scheme. So there was no mandatory bar, which is what we find in paragraph 3 of Annex D of the 2012 scheme. There was always a discretion to withhold or reduce the scheme. So the matter lay within the adjudicating officer's control. I turn now to trafficking obligations and the obligations that are imposed on states in international law. And there are two that are of particular relevance because they have a bearing upon the interpretation of the guarantees contained in the European Convention on Human Rights, and therefore through the Human Rights Act as a matter of English law. The first is the Council of Europe Convention Against Trafficking, and that is in the principal authorities at Authorities 4, page 589.
Ms. Kaufman, it may help if I say that we're all working off the electronic bundle.
So I can just give the bundle pages. I'm very grateful.
It's just the electronic page. Thank you very much.
I'm grateful. So page 589, we begin, and the court can, if necessary and in your own time, read in detail, but I'm just going to focus on a couple of the key provisions for our purposes. The first is at 590, and that is Article 1. Article 1 identifies the purposes of the Convention, and it's under the chapter heading, Chapter 1, Purposes, Scope, Non-Discrimination Principle and Definition. And if your Lordships and my Lady will read the purposes, 3 are articulated in 1. And after that, if you could read Articles 2 and 3. And on Article 2, I would ask the court to note that under the definition provided in ECAT, the Convention applies to all forms of trafficking in human beings, whether national or transnational. And that's relevant to A and B, who were trafficked transnationally into the United Kingdom. Moving on, at page 593, we enter Chapter 3, which is headed Measures to Protect and Promote the Rights of Victims, Guaranteeing Gender Equality. And within that chapter, if the court can move through to Article 15, page 595. Article 15, Compensation and Legal Redress. And I ask the court to read subarticles 3 and 4. Both of which are important when we come to look at Convention jurisprudence later on.
Ms. Kaufman, sorry for interrupting. Doesn't subparagraph 4 give an option to the state as to whether or not to set up, to establish a fund for victims of compensation, rather than a requirement to do so? Is the word "or" follows on the third line. So if Article 4 of the Convention is informed by this part of ECAT, then why is there an obligation to set up a fund for victims?
So the state must do one or the other. So it must either establish a fund for victim compensation or measures or programs aimed at social assistance and social integration of victims, which could be funded by the assets resulting from the application of the measures provided in Article 23. So it has to do one or the other. And we'll come later to the fact that the state has done this. So it has given effect to, in our submission, one of the obligations in Article 15.4, and there is no evidence that it is given effect to Article 15.4 by the alternative mechanism that is provided there. It's done this, it's chosen to give effect to Article 15.4 through extending the compensation provisions that already existed under the 2012 scheme. Yes, my lady.
Sorry, excuse me. I thought there were reparation orders that could be made and were made in this case.
Yes, that's a reparation order from the victims, from the perpetrators.
That's right.
Yes,
but it's still reparation.
Yes, and that's dealt with under 15.3. So 15.4 doesn't address reparations. That is provided for under 15.3, and then there is a separate obligation under 15.4. And it was actually, it was a slavery prevention order rather than a reparation order.
Thank you.
So that's Article 15, and we will come back to it. So if the court has any further...
forgive me. Am I right in understanding that this convention is not implemented into domestic law, but that its relevance is, as you've just indicated, in the extent to which it informs obligations under the European Convention on Human Rights?
It's precisely that, and I will come later to one of the ways in which we argue that the measures fall within the ambit of Article 4 is because it is our submission that Article 15.4 is, through the way in which the Convention is interpreted, an obligation, one of the positive obligations that fall upon the state under Article 4. But I will come to that in detail when we look at the relevant jurisprudence under the Convention. So it's not freestanding and it doesn't have any direct effect. It is through Article 4 and the Human Rights Act that it wins its way into domestic law. Can I then turn to Article 26, which is on, this is under the heading Substantive Criminal Law in Chapter 4. That title of Chapter 4 is at page 957. Article 26 appears at page 598. And that is entitled Non-Punishment Provisions. And each party is required, in accordance with the basic principles of its legal system, to provide for the possibility of not imposing penalties on victims for their involvement in unlawful activities, to the extent that they've been compelled to do so. So that's the non-punishment provision. And then finally, Article 40 in Chapter 5. Chapter 5 is headed, starts at 599, Investigation, Prosecution and Procedural Law. And Article 40 sets out the relationship of the Convention with other international instruments. And if your lordships and my lady can just read that. And then next, if you can turn to the EU directive on preventing and combating trafficking in human beings, page 1007, and that's the beginning. And then if you can turn to page 1013 and Article 8. That's entitled Non-Application, Non-Prosecution or Non-Application of Penalties to the Victim. Now, the EU directive builds upon the European Convention, builds upon ECAN. So you have a non-prosecution provision there. And next, if the court can turn to Article 17, compensation to victims. Member states shall ensure that victims of trafficking in human beings have access to existing schemes of compensation to victims of violent crimes of intent. So there is actually in Article 17 a very clear duty on the state to make provision, ensuring access to those schemes which exist. We detail in our case how it is that the 2012 scheme came to be enacted, and there was a consultation process. We set out the details of that process at paragraph 37 of our case, starting on page 66. And as we note, the particular provisions that were actually adopted at the end of the day by the government were different from those that were consulted. And I just want to look at a couple of the documents generated in the course of that consultation. If the court can turn to the appendix, and in particular to page 109. And this is within the document which starts at page 48, getting it right for victims and witnesses. This is the consultation.
Take over Ms. Kaufman for a moment, if you would, please. Appendix Part 2.
So it's the appendix part 2, I'm so sorry, yes, and it's page 49.
Thank you.
And 48 and 49 are the title pages to the consultation paper, January 2012. And the court can go into that consultation paper to page 109, paragraph 205. And it's at paragraph 205 that we find the two options that were actually consulted upon. Option A, all those with unspent criminal convictions should be excluded from claiming under the scheme, retaining a discretion to depart from this rule only in exceptional circumstances. Those who have spent convictions will be eligible. So there's that discretion doesn't apply in their case, they are simply eligible. And then under option B, there is a provision to exclude entirely from the scheme those who have unspent convictions for offences which would give rise to an award under the scheme, namely for violent and sexual offences, i.e. those who themselves have offences for the very offences perpetrated against them that would entitle them to claim will be excluded. And then those with unspent convictions relating to other offences would continue to have the discretion. And the government at paragraph 206, we can see in that first sentence favoured option A. And at 207, we see the rationale for the options that are being proposed. And if the court can read that paragraph, and the rationale appears on the 5th line down, starting the scheme is a taxpayer-funded expression of public sympathy. So as a taxpayer-funded public expression of public sympathy, there is a proxy of who is deemed blameless by reference to those that are excluded under the scheme or who must can only make a successful application in the event that a discretion in favour of them is applied by the adjudicating officer. And then at 208, we would expect option A, excluding all those with unspent convictions from making a claim under the scheme, to save between 4 and 5 million a year. Option B would save less. Can I then deal specifically with the position of victims of human trafficking? Their position was considered in the Equality Impact Assessment, which was published before introducing the scheme. That is at page 634 in the same appendix. And at the bottom of that page, paragraphs 205 to 206. Quality issues raised during the consultation. One respondent raised concerns about human trafficking victims. Sorry, there are some terrible grammatical errors here. Are they stated they are often charged with immigration offences which are inextricably linked with their situation of exploitation. Additionally, many victims of human trafficking are exploited as a direct result of their convictions in their country of origin. For example, women in prisons are targeted by human trafficking rings, which echoes precisely with the situation of the appellants. And then under the heading mitigation and justification on the next page, paragraph 207, second sentence, we consider that the policy based on seriousness of the disposal strikes the right balance between the aim that those who are of good character receive compensation and not barring those with more minor convictions from the possibility of receiving compensation altogether. I should say that this equality impact assessment was written in respect of the scheme that was actually introduced. So this is the scheme whereby anybody with an unspent conviction for those offences specified in paragraph 3 are excluded entirely, and there is a discretion for those with unspent convictions for less serious offences in paragraph 4. And then at paragraph 209, further, our reforms may also mitigate the potential effects raised by some respondents on human trafficking victims who have more minor convictions, such as for petty offences or immigration matters, which are closely linked to their having been trafficked. In such cases, the discretion which claims officers will have in respect of more minor convictions will allow them to take those circumstances into account. So regard is had there only to the circumstances of trafficking victims with more minor convictions, and no regard expressly in respect of trafficking victims who have more serious convictions but are nonetheless blameless for the offences for which they're convicted. And can we also look at paragraph 212 and 213? Again, a reference to the blameless victims. The scheme has always been intended to benefit blameless victims of crimes of violence. This isn't new. There have always been rules in place permitting claims officers to reduce or withhold altogether awards on the basis of criminal behaviour. We consider it proportionate to clarify and tighten those rules so that apart from in exceptional cases, no person with an unspent conviction which resulted in either a custodial sentence or a community sentence should receive an award. So you can see there that the discretion has always been a means by which an individual can be excluded where they are not blameless. And that discretion remains, albeit only in respect of paragraph 3, those individuals with less serious unspent convictions covered by paragraph 4. And then again, the scheme is a taxpayer funded expression of public sympathy. It is reasonable that there should be strict criteria around who is considered blameless for the purposes of determining who should receive a share of its limited funds. And your lordships and my lady read to the end there. So the scheme itself is at, I've got to come back to the main volume. That is at page 514. Now, the first thing to note about it is that it does give effect to the international obligations, those contained in 15.4 of ECAT and Article 17 of the EU Directive. And we can see this in paragraphs 10C and 13 and 16. So paragraph 10C is at 524. A person is eligible for award under this scheme only if, and then at C, one of the conditions in paragraph 13 is satisfied in relation to them on the date of their application under the scheme. And then at paragraph 13, if the court can read paragraphs 13 through to 16, those are all intended to give effect to the obligation to make sure that the scheme extends to victims of trafficking.
Forgive me, it's now 11 o'clock. 2-minute silence has now ended. Thank you for your mark of respect.
My lord, my lady, we were going to turn then to the scheme itself, and we were looking at, apparently we're looking at paragraphs 10C, 13 to 16.
Yes.
And once you've had an opportunity to read that, my lords and my lady, if you could turn to Article 26, which is at paragraph 26, which is at page 527. And that provides that Annex D shall set out or sets out the circumstances in which an award under this scheme will be withheld or reduced because the applicant to whom an award would otherwise be made has unspent convictions. And just before we turn to that, as we make our way through, if the court could turn to page 539, paragraphs 87 and 89 provide for time limits and the extension of those time limits. And then we have Annex D at page 554. And if the court could read paragraphs 2, 3 and 4. So I want now to turn to ambit and the basis upon which we submit that the scheme itself is such that any discrimination in its application does fall within the ambit of Article 4 in conjunction with Article 14 and has to be justified. And we put this in two ways. So the first basis, and this is where we come to the relevance of Article 15.4 through Article 4 of the European Convention. The first basis is that the state is actually under a positive obligation passed by Article 4 to provide trafficking victims with access to a compensation scheme, such that any discrimination in that access plainly falls within the ambit of Article 4. But even if, and this is the second basis upon which we put it, even if the court finds that there is no such duty or positive obligation rather cast under Article 4, it is nonetheless a scheme which the state has chosen to extend to victims of trafficking, see paragraphs 10C, 13 to 16. And as such, that is clearly something that is within the ambit of Article 14 because it's a classic positive modality case. And we'll come to look at positive modality cases a little bit later. I want to deal first with the primary basis upon which we put it. There is a positive obligation under Article 4. Under Article.
Before you move on to do that, could you just explain the word modality. You say it's a classic modalities case.
A
What
classic
precisely does that
positive
mean?
modality. So the language of modality came from a case called Petrovich, and we will come on to this, but it is an aspect of the very generous way in which Strasbourg interprets ambit, which we'll look at from the judgment of Lord Wilson in Matheson in a moment, that the interference, in order to come within the ambit, it isn't necessary for there to be an interference with one of the substantive rights at all. The substantive right doesn't even need to be engaged.
Yeah, I understand that. It's the use of the word modality and what precisely.
Yes. So if the state chooses to respect the right concerned by taking action it is not obliged to take, then that has been termed a positive modality case. And such cases fall within the ambit of Article 4.
Thank you.
Can I take you straight to Lord Wilson's comments or in his majority judgment in Matheson? That's at page 1860, tab 43. And at page 1864, you can see that he gives the lead judgment. Baroness Hale, Lord Clark, and Lord Reed agree with him. And then paragraph 17, page 1869, he says this: in his invocation of Article 14, Mr. Matheson therefore needs first to establish a link with one or more of the Convention's other articles. And he relies upon Article 8, and then fourth line down towards the end of that line, for the purposes of Article 14, Mr. Matheson does not need to establish that the suspension of DLA amounted to a violation of Mr. Cameron's rights under either of those articles, otherwise Article 14 would be redundant. He does not even need to establish that it amounted to an interference with his rights under either of them. He needs to establish only that the suspension is linked to, or as it is usually described within the scope or ambit of one or other of them. So the language of linked to is important there. So positive modality cases are linked to the substantive right because they are a means of enabling those who are the possessors of that right to further enjoy their exercise. So does Article 4 oblige the state to establish this scheme? There are three Strasbourg cases that are relevant. The first is Rancev, the second is Chowdhury in Greece, and the third is SM and Croatia. And I'd like to start with SM and Croatia. This is a decision of July this year of the Grand Chamber in Strasbourg, and it's the first time the Grand Chamber has had an opportunity to look at Article 4 and its application to victims of trafficking. It's the judgment is at page 740. That is tab 8. So bear with me a moment. I'm just going to get myself to it. If I can ask the court to turn to paragraph 277, and that's page 808. And just read 277 and 278. And thereafter, the court set about looking at its own jurisprudence and international instruments to answer the question of whether trafficking in human beings, albeit not identified under Article 4 expressly, nonetheless is a form of ill treatment that falls within the scope of Article 4. And it concluded that it is, and it does, and in so doing, it upheld the Rantsev decision, the Siliadin decision, which it reviewed in the paragraphs that followed from those which you've just read. And at paragraph 286, it says the most important development, that's page 810, in the court's case law on the issue of human trafficking for the purposes of sexual exploitation occurred with the adoption of its judgment in the case of Rantsev. And at 287, in this connection, in particular, the court noted that there was no mention of trafficking in that provision. However, having outlined the various international instruments in the field of human trafficking, the court referred to the following interpretive principles of the Convention. And I would ask your lordships, in my lady, in your own time, to look at that analysis and the way in which it drew upon interpretive principles, the Vienna Convention, and the international instruments relating to trafficking, all the way down to page 812 and the quoted passage at 282 from the Rantsev judgment. And there at 290, the court notes that from the Rantsev judgment, the court concluded that the impugned conduct may give rise to an issue of human trafficking under Article 4 for the purposes of the Convention, only if all the constituent elements of the international definition of human trafficking are present. And then if you can look at paragraph 292, having regard to these observations, the concept of human trafficking can properly be incorporated in the court's view within the scope of Article 4. Indeed, given the Convention's special features as a human rights treaty and the fact that it is a living instrument which should be interpreted in light of present-day conditions, there are good reasons to accept the assertion in Rantsev. The global phenomenon of human trafficking in human beings runs counter to the spirit and purpose of Article 4 and thus falls within the scope. And then at 294, it notes a difference between the Palermo Protocol, which is the UN protocol, and ECAT in terms of the scope of the application. The third line down, the latter being applicable to all forms, that's the Anti-Trafficking Convention, of trafficking in human beings, whether national or transnational. And I specifically noted that point with the court earlier on in relation to ECAT, whether or not connected with organised crime, whereas the former relates to transnational trafficking involving an organised criminal group. It is therefore necessary for the court to clarify its position on that particular point. And it says at 295, in the court's view, there are several reasons why the approach under the Anti-Trafficking Convention should be followed. And it sets up the first reason, and then the court goes down to about 6 lines from the bottom. Halfway across that line, there is the word secondly. Secondly, the court has already held that the member states' positive obligations under Article 4 of the Convention must be construed in the light of the Council of Europe's Anti-Trafficking Convention, and it cites the case of Chowdhury. After having identified trafficking as falling within the scope of Article 4, that is clarified again at 296, the court then goes on to consider the positive obligations that are and have been identified as falling upon the state under Article 4. And that is at 304, page 816, heading 3, states' positive obligations under Article 4 of the Convention, the scope of the state's positive obligations concerning human trafficking and forced labour. And it notes again that these were comprehensively Well, firstly, the important point is to identify why the concept of positive obligations arises, because Article 4 enjoins the state not to ill-treat individuals, but the positive obligations arise in order for the state to take measures to prevent private persons from engaging in the kind of ill-treatment that Article 4 prescribes. And many of the positive obligations cast by Article 4 are targeted at ensuring that the state takes measures to prevent ill-treatment by private persons and to protect victims of such ill-treatment. And at 305, the court says that it looks to Ransome as having comprehensively set out the positive obligation. And these are then reproduced by quoting paragraphs 283 through to 288 of the Ransome judgment. I would ask that the court, again, does read this in your own time, because there are a number of different obligations that are identified. But we can see at 284 that there must be a relevant legal and regulatory framework in place, and the court considers that the spectrum of safeguards set out in national legislation must be adequate to ensure the practical and effective protection of the rights of victims of potential trafficking. Accordingly, in addition to criminal law measures to punish traffickers, Article 4 requires member states to put in place adequate measures regulating businesses, often used as a cover for human trafficking. Furthermore, a state's immigration rules must address the relevant concerns relating to encouragement, facilitating, and tolerance of trafficking. And the court then goes on to identify in the following paragraphs an operational duty to take measures to protect a victim of trafficking when the state knows or ought to know that they're at immediate risk. And that's a duty which has been brought across from Article 2, the Osman case, through to Article 3, Z in the United Kingdom, and now into Article 4. And then there is also a duty, a procedural obligation, which is identified at paragraph 288, a procedural obligation to investigate potential situations for trafficking. The requirement to investigate doesn't depend on a complaint from the victim or next of kin. Once the matter has come to the attention of the public authorities, they have to act of their own motion. And if the court reads quickly through that, to the conclusion of paragraph 306 of the judgment of the Grand Chamber in SM, where it identifies the positive obligations as one, the duty to put in place a legislative and administrative framework to prohibit and punish trafficking, two, the duty in certain circumstances to take operational measures to protect victims, and three, a procedural obligation to investigate situations of potential trafficking. In general, the first two aspects of the positive obligations can be denoted as substantive, whereas the third aspect denotes a procedural obligation. And I should say, in relation to the procedural obligation, this is a criminal obligation. It's an obligation to conduct a criminal investigation to ultimately bring prosecution in order to hold individuals to account and punish if necessary. So we saw that the Chowdhury case was mentioned as the one which had identified the way in which Strasbourg interprets the content of those positive obligations by reference to ECAP. Chowdhury
Pausing there, Ms. Kaufman, is there anything in SM which specifically deals with compensation by the state?
No, doesn't touch upon it. It wasn't an issue that arose in that case.
Right, thank you. But your point is it endorses Chowdhury.
It endorses Chowdhury, and it makes it clear, absolutely clear, the role that ECAP plays in interpreting the positive obligation.
Thank you.
So Chowdhury is at page 695. The relevant paragraphs are 86 to 87. We have reference to Rantsev, to the obligations that are imposed, the positive obligations that are imposed. all the way through to 89, we can see all those obligations identified by the Grand Chamber in Chowdhury being identified here in these paragraphs. And then if we turn paragraphs 103 and 4, page 729, the heading, the respondent states positive obligations under Article 4 of the Convention. And the court reiterates that Article 4 of the Convention may in certain circumstances oblige the state to take operational measures to protect actual or potential victims of trafficking. More specifically, the positive obligations under Article 4 must be construed in light of the Europe's Anti-Trafficking Convention to be seen as requiring, in addition to prevention, victim protection and investigation, together with the characterisation as a criminal offence and effective prosecution of any act aimed at maintaining a person in such a situation. The court is guided by that convention and the manner in which it's been interpreted by Britain. And then at paragraph 110, there is the heading operational measures. And if you follow that down, we then get to a heading little Roman numeral 3 of paragraph 116, effectiveness of the investigation and judicial proceedings. So we're now dealing with the procedural obligation, the effectiveness of the investigation. So this is about holding to account victims of trafficking through the criminal process. And if you follow right down to paragraph 123 on page 733, heading as to the applicants who are parties to the assize court proceeding. And the court then looks at those assize court proceedings and it moves at the bottom of that paragraph. It notes at 5 lines from the bottom, on this point, the court reiterates its finding that the Patras Assize Court adopted a narrow interpretation of the concept of trafficking, relying on elements specific to servitude in order to avoid characterising the applicant's situation as trafficking. That's a clear failure that has been identified. And then at 126, lastly, the court finds that even though TA and one of the armed guards were found guilty of grievous bodily harm, the assize court only ordered that they pay compensation of €1,500, i.e. €43 per injured worker. However, Article 15 of the Council of Europe's Anti-Trafficking Convention obliges contracting states, including Greece, to provide in their domestic law for the right of victims to receive compensation from the perpetrators of the offence and to take steps to establish, inter alia, a victim compensation fund. So they make reference to the obligation to, among other things, establish a victim compensation fund. They specifically identify failure to adhere to the requirements of Article 15 and then conclude at 127, having regard to the foregoing, the court finds that there has been a violation of Article 4.2 of the Convention as a result of the state's procedural obligation to guarantee an effective investigation and judicial procedure in respect of situations of human trafficking. Now, they're not dealing with the compensation scheme. I accept that. I am arguing that by extension of and application of the principle there articulated, Article 15.4 is part of the positive obligations passed on states to make good where victims of trafficking have been injured by private citizens. And can I finally, on this point, take the court to MS and Pakistan, which is a decision of this court, tab 31, page 1412. And Baroness Hale, Lady Hale's judgment, paragraphs 22 to 31, she looks, that's page 1421, she looks in detail through the Strasbourg jurisprudence, she looks at Siliadin, she looks at Rantsev. Of course, SM hadn't been decided by then. And she looks at Chowdhury. And then at 31, she makes this observation. And this was before the approach in Chowdhury was endorsed in SM. Thus, the judgment does follow the same analytical framework as the judgment in Rantsev, but it more noticeably relies upon specific provisions in ECAT to flesh out the content of these positive obligations. So that has been noted by this court. We now have the judgment in SM, which makes it clear that is the correct approach, fully endorsing the approach of the Chamber in Chowdhury. So we submit that in construing Article 4 and its positive obligations in light of ECAT, as the Grand Chamber fully endorsed, consistently with the fundamental interpretive obligations under the Convention, Article 15.4, just as the Court found in Chowdhury, Article 15.3, informs the content of those positive obligations and is indeed an aspect of those positive obligations.
Does that mean that every obligation under ECAT is automatically transplanted via Article 4?
That's not my submission, but I don't need to go that far. The jurisprudence does say in terms that it must be interpreted in light of, and the court itself has done that in relation to Article 15.3 and 4 through its judgment in Chowdhury, which has been endorsed in SM. So in Chowdhury, they specifically identify the duty on the state to make compensation, albeit they're not concerned with that. They do make clear that Article 15.3 is an aspect of the court's obligation, and they are effectively a flip side of each other. You have to make provision for compensation from the victim, but insofar as the victim's compensation or doesn't adequately compensate, then the state must do so in its stead. So they are linked obligations, and therefore, in our submission, the recognition of one endorsed by the Grand Chamber necessarily entails the recognition of the other. So I don't submit that every single one will be. I think it's going to be a question of looking at those obligations and seeing how they fit into the larger, more general obligations. That is the obligation to take operational measures, the obligation to investigate, and the extent to which they fall specifically within those.
It's simply that the language of interpreting in the light of is rather vague, isn't it?
It is vague, and that's why I don't suggest that one automatically moves in to Article 4 every single obligation. You have to look at the positive obligations that have been identified in Article 4, the obligation to legislate and introduce a system, the obligation to take operational measures, and the obligation to criminalise and investigate. And insofar as ECAT itself and its particular provisions bear upon those obligations and giving effect to them, then it's in those circumstances in my submission that one would say that the provisions of ECAT become relevant and inform and are carried into the discharge of the positive obligations in Article 4.
Thank you very much.
Stewart is a case relied upon by the respondent, and I am going to deal with it now as I go through, because in our submission there is a very short answer to Stewart. Stewart was a decision made taken in 1999 by the court, an admissibility decision. It's at Authorities 9, page 853.
There's a question from Lord Stevens.
I'm so sorry.
Not so. I'm sorry just to take you back to page 596, which is paragraph 15.4 of ECAT, which is the provision that informs the obligations under Article 4. But on my reading of it, and you contrasting it with page 734, it doesn't require a state to set up a compensation fund. So if you're looking to see what Article 15.4 does, it provides that it provides a degree of discretion because it uses the word may. It provides instances of how it sets about it, and it provides the suggestion that it could be funded by assets resulting from the application of measures provided in Article 23. Well, so I just wonder why one then jumps from that to the state has a positive obligation to set up a compensation.
So it requires a state to adopt such legislative or other measures as may be necessary to guarantee compensation for victims in accordance with the conditions under its internal law. For instance, through the establishment of. So it does in terms require it to adopt such legislative or other measures as may be necessary to guarantee compensation. So insofar as, and they are simply instances of how it may do it, and then Article 17 of the EU directive, which adds to ECAT, makes it quite clear that there must be a state compensation scheme. So in my submission, it does make it clear that there must be a scheme or a mechanism providing for compensation.
Yeah, thank you.
Then 853 is the Stewart decision, and 855, so this was under Article 3. So here the complaint was a lack of access to compensation under for somebody who'd been ill-treated in a way that was contrary to the guarantees of Article 3, not to be subjected to inhuman or degrading treatment or torture. So under the citation of Article 8 on page 855, the court says this: it recalls that the obligation of high contracting parties under Article 1 of the Convention to secure to everyone within their jurisdiction the rights and freedoms defined in the Convention, taken together with Articles 3 and 8, requires states to take measures designed to ensure that individuals within their jurisdiction are not subjected to torture or degrading treatment or punishment or grave interference, etc., including ill treatment administered by private persons. So this is the first recognition that the state has obligations in relation to the acts of private persons. It's not just a convention that obliges the state not itself to engage, but it actually has to do something to stop. And the A in the United case is cited, and further on in that paragraph, it says children and other vulnerable individuals are entitled to state protection in the form of effective deterrence from such ill treatment. Now, I'm going to show you in a moment that at this point in time, back in 1999, the extent of the obligations cast upon the state by Article 3 were only to ensure that there was effective deterrence from such ill treatment, and that was by ensuring that the ill treatment was prescribed in criminal law. But the positive obligations had not extended beyond that. Reading on, if the court could just read on the next paragraph, this is why the court then finds there's no need to provide a compensation scheme. That was the complaint. So the first time the court recognised the operational duty, the one I referred to earlier as the Osmond duty, the duty to take operational measures to protect an individual at real and immediate risk of ill treatment, was in Z in the UK. That is in Authorities 85 at page 3255. we can see in the Commission's decision, when we have both the Commission and the Court's report here, at page 3272, we have reference to the positive obligation to effectively deter.
Which paragraph is that?
I'm so sorry, that is at page 3272, C93.
93, thank you.
The Court just reads that paragraph. So it was simply deterrence through criminalisation that had thus far been recognised. And then going on into the Court's judgment at 3278, paragraph 73, the Court addresses why it is that there needs to be steps taken by the state to take measures in relation to individuals who are harmed by private citizens. And at the very bottom of that paragraph, where 27 appears at the beginning of the line, should be a footnote 27, these measures should provide effective protection, in particular of children and other vulnerable persons, and include reasonable steps to prevent ill treatment of which the authorities had or ought to have known. And that is the first reference to the Osman duty, as it were. And if the Court turns to page 3293, that is footnote 28, and you can see that they reference Osman. Now, Osman was a case which arose under Article 2. So it was a duty to take operational measures to protect a life which was at real and immediate risk in circumstances where the state should have known about that risk. In Z, they transfer or they extend that obligation to Article 3. And in Rantsev, they extended it to Article 4, many years later. And the duty in relation to which in Chowdhury, the Court identified that Article 15.4 had a bearing upon the interpretation of Article 4 of the European Convention of Human Rights was the procedural obligation, the criminal investigative obligation. Now, that obligation was not recognised in relation to Article 3 until a case called MC in Bulgaria. And I believe that the MC authority was provided to the Court yesterday. I'm very sorry if it hasn't reached the Court and your Lordship to my lady. It has.
We have it.
I'm very grateful. Well, this was a case of rape, and it was a case arising under Article 3. And the Court at paragraph 148 began its general approach. 148 is on page 28. The existence of a positive obligation to punish, rape, and investigate in rape cases. There's that reference to investigate. And you can see, you read through 149 down to 151. It identifies those obligations that have already been identified as inhering in Article 3. Then at 152, it says this: further, the Court has not excluded the possibilities that the state's positive obligation under Article 8, oh sorry, that's with Article 8, I apologise. So, then it turns at 153 to identify what is the never before recognised obligation. On that basis, the Court considers that the states have a positive obligation inherent in Articles 3 and 8 of the Convention to enact criminal law provisions effectively punishing rape, and then critically this, and to apply them in practice through effective investigation and prosecution. And since the MC case, there have been numerous cases through Strasbourg which have looked at the criminal investigative obligation. And indeed, in this court, in the case of DSD and NBV, it was recognised that such an obligation inheres under in Article 3 under the Human Rights Act. So there is a duty to conduct an effective criminal investigation, but that wasn't recognised until many, many, many years after the Stewart decision was taken. So in our submission, Stewart is nothing to the point, because the obligation in respect of which, the positive obligation in respect of which Article 15.4 applies, simply hadn't been recognised by the European Court at the time. So that's our case on ambit, if we are correct that Article 15.4 ECAT is part of the positive obligation, positive procedural criminal obligation under Article 4 of the Convention. And plainly, it's, I'm so sorry, my lady.
Let's get to the end of the proposition. I want to ask a question.
So plainly, if the complaint is about the application of something the state is bound under Article 4 to take steps to give effect to, then there's no question that it's within the ambit, given the very generous nature of the term, as Lord Wilson identified in Matheson, my lady.
It was just an observation about Z. Whoops, gone on to mute again.
I can hear you. Oh, it's gone mute.
An observation.
No, you've gone mute again, I'm afraid.
An observation about Z and a question. In Z, the main point was whether or not the children who had been treated abusively had a cause of action against the local authority in negligence. And under English law, there was no duty of care. And so the question, the principal question was surely whether or not that involved a violation of their human rights, and it was held not. So that in that case, there was no viable claim for compensation through an action against the local authority who had been responsible for child protection.
Yes, that's right. So there were a number of issues in Z. One of them was the question about whether or not it was a violation of Article 6 for there to be no cause of action against social services. That was one issue. There was then the separate issue of whether or not there was a duty on the state under Article 3 to protect the children. So it was an entirely separate question and entirely in a very different part of the decision. What wasn't an issue in that case was whether or not Article 3 casts an obligation on the state to make provision for a compensation scheme. That wasn't an issue at all, but the reason I'm looking to this case is to demonstrate that the Stewart case was one which was decided very early on in the development of Strasbourg jurisprudence on the nature and existence of positive obligations, and to make the point that the positive obligation, that is, the criminal investigative obligation, which in Chowdhury, the court said, includes a duty in respect of compensation by reference to Article 15, had nowhere been recognised as existing at the time that Stewart was decided. So Stewart cannot, for that reason, be invoked as an answer to the position we are in today as a result of Chowdhury and SM. That's the point I'm making.
Right. Thank you.
So that might be a convenient moment if you've come to the end of your first. The first was really the first half of your first point.
First half of my first point. Yes.
You have until 1:15, I think.
I do. And I'm getting very worried now that I've got awful lot to get through.
Well, we'll take a very short break, and then we'll resume, so you can get on. Thank you very much. Ms. Kaufman.
So we've completed the first way in which we put ambit, and the second way that we put ambit is on the basis of this being, that is, the extending of the scheme to victims of trafficking being a positive modality. So before I take you to Petrovich, can I just ask your lordships and my lady in your own time to look at what Lord Justice Higginbottom in the JCWI case in the Court of Appeal said about the domestic court's approach to ambit. He said at paragraph 83, page 1769, and I'm not going to take you to it, that the European Court of Human Rights has taken a relaxed and loose approach to the concept, in contrast to the very heavy weather that Lady Hale observed. In another case, the domestic courts have made of this concept. So the starting point is, it is a very generous approach. You're looking for a link. You're not looking for some carefully analysed connection, but just some kind of link. And that's what the positive modality cases are all about. A link arising from the fact that the state has extended the scheme or has taken measures that it isn't obliged to do under the particular convention right, but which then benefits individuals in the enjoyment of that right. So Petrovich is at page 3082, and the relevant paragraph is at page 3090, and it's paragraphs 26 through to 28. So that's where the word modality appears for the first time, and then in our courts, these cases have been spoken of as positive modality cases ever since. We also, in our case, highlight the case of Zar Adami, which is well worth a read at some point, because Sir Nicholas Bratzer, in his own separate opinion, really exemplifies the very, very generous approach to ambit, and how it was that the court found in that particular case that somebody who was subject to compulsory service and therefore expressly not within the ambit, not protected by Article 4, how his complaint nonetheless fell within the ambit. So in our submission, even if Article 15.4 does not find its way into Article 4, either because Lord Stevens is right that it doesn't require the state to provide compensation, or because it isn't one of those rights that is incorporated into Article 4 or duties, then this is nonetheless a clear case where the scheme falls within the ambit of Article 4, because the state has decided to extend it to victims of trafficking, and we saw that with paragraphs 10c to 13 and 13 to 16. This isn't even on the margins as to whether or not this falls within the ambit. It clearly does on one or other of the footings we've put forward. So we then move on to status, and again we submit that this is again an entirely straightforward issue. We put it on two bases in our written case. Firstly, A and B status is...
Sorry, I'm going to take this a little bit slowly, if you would, Ms. Kaufman, because it was what I was going to ask you, is precisely how you put your case on this.
Yes.
So
we put the status of A and B as on two different footings. The first is that they are a victim of trafficking. And in relation to that status, their cases fall to be compared with other individuals with spent convictions who are caught by paragraph 3. That is, who are excluded under the scheme because they have unspent convictions for offences specified in paragraph. That's the group that they compare to. And the argument is that they are relevantly different to other victims of trafficking and should be treated differently. That's the Flimenos argument.
Forgive me, the argument is that they're materially different from other victims of trafficking.
No, victims of crime, I'm so sorry. Other victims of crime who are caught by paragraph 3.
Thank you.
Within the class of victims of crime, victims of trafficking are relevantly different and should not be caught by paragraph 3, or the state is required to justify why it is not treating them differently from other victims of crime. And then the alternative way we put it is to look at the class of victims of trafficking. And among the class of victims of trafficking, those victims who are caught by paragraph 3 are treated differently from those victims who are still able to apply under the scheme with the benefit of the discretion under paragraph 4. And our case there is that they are not relevantly different, and therefore it's necessary to justify why they are being treated differently from other victims of trafficking who can apply under the scheme. Now, in relation to the first basis...
I've not understood you previously to put the case on this second basis.
So can I have take us to how we did put it? So it's in the statement of facts and issues at page 55.
Well, it may be you don't want to take up time on this because you're under pressure as to time.
Yes,
I have to say that I had understood your case to be that victims of trafficking should be treated on a different basis, and it was put on that basis.
Yes, that's our primary argument. They should be treated differently from those who are victims of crime and who are not victims of trafficking. That is our primary case. Victims of trafficking should be treated differently. There is another way it can be put, which is to compare them with other victims of trafficking and to say, well, those with these particular type of offences should be treated the same as victims of trafficking who can apply under the scheme. I am content to put it on either basis. It's analytically exactly the same. It's the same justification that has to be offered. But certainly treating victims of trafficking as a separate class from other victims of crime caught by paragraph 3 is the most straightforward way to do it, and I'm very content to proceed with that initially.
That's fine. Don't let me detain you any longer.
In our submission, it's unanswerable that a victim of trafficking is a status for the purposes of Article 14. Unquestionable that they meet that provision. We don't even need to go into all the complications of whether or not an individual with a sentence of a particular length has a status for the purposes, or a particular type of sentence is a status for the purposes, because it is so clear that a victim of trafficking is a relevant status. But I start with Matheson. We've already looked at that, page 1860, tab 43. And this time we want to look at paragraph 19, page 1869. And at the bottom of the page, status is the heading. And then at H, Mr. Matheson argues that Cameron's status on the 6th of October 2010 was that of a severely disabled child who was in need of lengthy inpatient hospital treatment, and that in comparison with a severely disabled child who was not in need of lengthy inpatient hospital treatment, the application to Cameron of an 84-day rule discriminated against him. So both individuals, for comparison purposes, are severely disabled. What distinguishes them is one is in need of hospital treatment, lengthy, and the other isn't. So the status has to come from the need for lengthy hospital treatment, because that's the distinction between them. And if your lordships turn to paragraph 20, Lord Wilson says at the top, first sight, Mr. Matheson's contention appears contrived. Does it pass muster? And then if your lordships will read paragraphs 21 and 22 and 23. So there is the general observation that status tends not to refer to something done to someone, but it's quite clear from the RGM case itself that that is not an exclusionary rule. The status can arise by reason of something being done to someone, and that's made absolutely abundantly clear in Clifton, the United Kingdom, which is at tab 66, page 2584. And that is, if the court would then turn to paragraphs 58 to 60 there, which is at page 2601. So here, Clifton in the House of Lords went up to Strasbourg. In the House of Lords, it had been held, unhappily, but on the basis of where the House of Lords considered Strasbourg jurisprudence stood at the time, that a sentence of 15 years imprisonment or more was not a status for the purposes of Article 14. In Clift and the United Kingdom, Strasbourg disagreed. And 58 to 60 is the critical passages where the court sets out the proper approach. So three very important points to take. The first is, one looks at the sorts of cases where status has been identified as existing. An individual who is a holder of outline planning permission, who benefited from new legislation, and holders of outline planning permission who did not. I mean, plainly things that have happened to an individual and utterly incomparable to a victim of trafficking, for reasons that I will come to. Secondly, there is the point that the court in Strasbourg did not agree that the status must exist independently of the measure that is complained of, because one of the issues that arose in Clift was there was no significance in relation to the length of your determinate sentence, i.e. whether it was 15 years or more or less than 15 years, separate from the early release provisions which were then attached to that sentence of that length or more, which was the subject of the complaint. And the court said that doesn't prevent it being a status. And then, critically, what you have to look at in order to decide whether or not there is a status is identified at paragraph 60, and it is based on whether there is a different treatment based on a personal or identifiable characteristic in any given case, and matters to be assessed taking into consideration all the circumstances of the case and bearing in mind the aim of the convention is to guarantee rights that are not theoretical or illusory. Then we have Stott.
Well, before we move to Stott, help me on the second point, if you would. It's said against you that the Supreme Court has stayed with the old rule in Doherty.
The old rule that it must exist independently. Yes, I was going to come back to that, if I might.
But it's a point I'd be grateful if you could deal with at some point.
I was going to come back to that in reply, just to give myself more time now, but I will deal with it. But in any event, our case is that doesn't matter, because this isn't a situation where our status did not exist independently of these measures. If one looks at the status as a victim of trafficking, that is entirely independent of these measures. If one looks at our status as against other victims of trafficking, being that we have a sentence which resulted in unspent convictions of the kind specified in paragraph 3, those sentences do not derive significance from paragraph 3 alone. Those sentences derive their significance from the Rehabilitation of Offenders Act. Those sentences are identified and created under the Rehabilitation of Offenders Act, which sets out what the period is during which a conviction will be unspent, and sets out in that legislation and other legislation implications and consequences that attach to unspent convictions as long as they remain unspent. So the notion that an unspent conviction for those kinds of sentences has no significance other than under this legislation is nonsense. And we identify in our skeleton argument the ways in which unspent convictions are significant other than by reference to this scheme. All this scheme does is add another consequence to having an unspent conviction. So it is a million miles away from the sentence of 15 years imprisonment under consideration in Clift. But of course, that's only if we look at our status as having that sentence. So the primary way in which we put our status is that we're a victim of trafficking, which plainly has an independent existence from this scheme. Stott is analysed in detail in our submissions. What I would just like to say about it now is that the consequence of that decision is that a sentence of imprisonment of 15 years is plainly now recognised in English law as a status for the purposes of Article 14, as is an extended sentence, which was the sentence which was in issue. So in my submission, all the sentences specified in paragraph 3, or rather all the unspent convictions specified in paragraph 3, equally must be statuses for the purpose of the convention. And can I just very, very quickly look at the Rehabilitation of Offenders Act, if I can find it. Your Lordships and my lady will just bear with me 1 second. Just need to find tab 15. It's tab 15. Tab 15, page 911, and the relevant provision is section 5. This is where paragraph 3 comes from, because it's section 5 that identifies these particular unspent convictions. It's entitled, page 913, Rehabilitation Periods for Particular Sentence. The sentences excluded from rehabilitation under this Act are a sentence of imprisonment for life, a sentence of imprisonment, etc., etc. And when we go back to paragraph 3, you will recall that the scheme does not apply to those sentences which are excluded from rehabilitation. That's the first of the sentences which are identified in paragraph 3 of Annex D. Then if you look down at paragraph 2 of section 5, subsection 2, for the purposes of this Act, subject to section 3 and 4, the rehabilitation period for a sentence is A, beginning with the date on which the conviction in respect of which the sentence is imposed, and B, ending at the time listed in the following table to that sentence. And if you then look at the table, you will see all the sentences identified in paragraph 3 of Annex D. And the only ones that aren't in paragraph 3 are at the bottom, a relevant order, and then above a community and youth rehabilitation order, a compensation order and a fine. And that's because paragraph 4 applies to them. So the existence of all these measures, of all these sentences or unspent convictions rather, is separately identified. And as I say, we address in our case all the implications that the law imposes in respect of unspent convictions. They are plainly established. And all this legislation does is add an additional consequence. So in our submission, it is clear that whichever way one looks at this, the appellants have a relevant status, which brings us then on to the question of whether or not they are treated differently. And as I've already explained, our case is that as victims of trafficking, they should have been treated differently from other individuals who are victims of crime and caught by paragraph 3. Or rather, the state should justify the failure to do so. My Lord Stevens.
Why is that so? I mean, it's obviously an awful infliction to be humanly trafficked. But there are other crimes, victims of other crimes, that are appalling. And so why is it that this should be a special case?
That's exactly what I'm going to come on to now. That's what I'm going to explain, our case as to why they should be treated differently. So first, I just want to deal with the principle that Strasbourg, that Article 14 doesn't look just at a failure to treat like cases alike. It also looks at a failure to treat cases that are differently and requires justification for that. You obviously have to satisfy the court that the cases are relevantly different. So the case is Slimanos, and it's at tab 10, and I want to look at paragraph 44, which is on page 870. And if I can ask your Lordships to read paragraph 44 down to 47. So two things to note there, three things to note. Firstly, it does establish that there is a requirement to ask whether or not different cases should be treated differently. Secondly, in paragraph 46, you will have seen that what has to be justified, where you're satisfied that there are different cases, is the failure to treat these individuals differently. So the court will have to examine whether the failure to treat the applicant differently from other persons convicted of a felony pursued a legitimate aim. You're not looking at whether the measure itself pursued a legitimate aim, but whether or not there was a legitimate aim being pursued in failing to treat different cases differently. And here, they looked at the legitimate aim of the scheme itself, and yes, it was perfectly permissible and legitimate to exclude some offenders from the profession of a chartered accountant, but then they looked at the particular situation of somebody who was convicted on the basis of their political and philosophical and religious beliefs, and said that is a situation that needs to be treated differently, and you need to justify why you haven't done so. I.e., because of their conscientious objection and beliefs, they have Article 9 protection, and the state needs to think about them differently and treat them differently unless it can justify that there is a legitimate aim for not doing so. So why, as my Lord Stevens asked, should victims of trafficking be treated differently? And we put forward two bases. The first is that as victims of crime, they form a very, very distinct group. And that is apparent from everything we've looked at in relation to the international conventions that protect them and require states to take very extensive measures to identify, protect them, and secure justice for them, and recompense, etc., etc. And not only is that something that the states are obliged to do under the international conventions, but we are also obliged to do that under the Human Rights Act because they are protected under Article 4, and that entails all the positive obligations that are then owed to them. So that's the first point. But the second point is one which is referable to this scheme and something that distinguishes them under this scheme. And it's been touched upon already in the equality impact statement. But it's this, that what distinguishes victims of trafficking as a special group is not just that they're subject to a truly dreadful crime, but that the nature of the crime is such that they are liable by virtue of the particular way in which these crimes are committed themselves to commit offences for which they are blameless, i.e. they are compelled to commit them in the course of the trafficking, or having, as in our situation, they are identified and picked on because of the vulnerabilities that have involved them in crime. But focusing only, yes, my lord.
But the second one doesn't arise on the facts of this case.
It doesn't, but that doesn't prevent, on the facts of this case, us arguing that victims of trafficking fall to be treated as a different group. And that's the argument. We are a victim of trafficking, and we are identifying how this legislation, this secondary legislation, discriminates against victims of trafficking. Whether ultimately we would succeed under a scheme that didn't so discriminate is another question. But we're not there yet. We are simply at the point of saying this scheme discriminates and it needs to be justified, because victims of trafficking form a very special and unique group by virtue of the nature of the offence committed against them. And we've seen Article 26, the non-punishment provision that requires states to take measures to ensure that precisely where they are involved in criminality, which is compelled by the offences committed against them, then they shouldn't be punished for it. So that manifests and demonstrates the special nature of this group. My lady, Lady Arden.
Just last point. How make a point?
My lady, your sound keeps going in and out. I'm afraid I didn't catch any of that. You've gone mute again. Now, I'm sorry, I can't.
No, I think I must have I will leave the question.
I'm sorry. I just can't.
Ask the technical advisors to deal with that.
Ms. Kaufman, can you help me on this one, please? I can see why it might be argued that a group of victims of trafficking should be given different preferential treatment, and that group of victims of trafficking would be those whose offences are connected with their status as victims of trafficking. I understand the submission that you make would work in those circumstances, but here we're not concerned with victims of trafficking whose offences have that connection.
That is true, but what we have is a victim of trafficking, and as a group, and it may not apply to every victim of trafficking, but as a group of victims of crime, victims of trafficking form a special class precisely because, and it won't be the case with everybody, and that's why the scheme, as we can see, is already tailored to deal with those individuals who are blameworthy and aren't, and not everybody who is not caught under paragraph 4 will be entitled to claim under the scheme. On the contrary, it will only be in exceptional circumstances that such an individual will be entitled to claim under the scheme. But victims of trafficking as a class include individuals who will be able to benefit from that discretion and satisfy the aim of the scheme of only benefiting those who are blameworthy. So paragraph 4 also includes victims of crime who are, and other victims who are not blameworthy. And what they must do is they have to satisfy that the exercise of the discretion should be made in their favour. So it isn't correct that the group in question must be narrowed down to victims of crime who are nexus offences. And I also add this, the scheme is aimed at individuals who are blameless. And there are some victims of trafficking who will be blameless because it's a nexus offence, that is, it's one that's committed in connection with the offences. But there are also others who will be trafficked precisely because they are already offending. So women who are in prostitution, for example, or children who are in prostitution and have convictions. And the scheme would enable a discretion to be exercised in relation to them. The nexus the nexus victims are the most obvious, but it doesn't mean that they are all of them, because trafficking is a very complicated thing and it works on exploitation. And it works on exploitation of the already vulnerable, who may already have committed crimes for which they were not blamed. So it's neither correct that because these individuals were not themselves victims of a nexus crime, that they don't have any standing to bring this, because it is all victims of trafficking who fall to be treated in the same way as others in paragraph 4. Lady Arden.
Yes, it's really the last point. How can you bring a claim on behalf of a group of which you're not a member, namely those who have offences where a discretion might be exercised? Because you're accepting that these offences were independent and are indistinguishable from other unspent convictions of victims of a crime who have committed an offence in the past and therefore excluded by Appendix D. So it's a question really of bringing human rights proceedings. How can you allege a violation, a breach, on behalf of a group of which you are not a member?
Because what I am challenging and what my clients are challenging is a piece of legislation of general application, which, if I am right, unjustifiably excludes victims of trafficking, of which I am one. So I'm not challenging the application of that scheme to me in this particular case as an individual discretion. My case is this legislation offends the convention because it discriminates against victims of trafficking, and I am a victim of trafficking.
Well, can you produce some authority to show that you can claim on this relief, even though you're not yourself claiming that you would benefit from the finding at the end of the day.
I'm not saying whether I would or wouldn't benefit, because at the end of the day, the outcome that I am seeking is that victims of trafficking, all victims of trafficking, are excluded from the application of paragraph 3, such that they are able to apply under paragraph 4 and seek to have a discretion exercised in their favour. So it may be that were I able to make submissions, I would be able to convince an adjudicator that compensation should be paid to me. But I am a victim for the purposes of this challenge, because this challenge is to the legislation. And I am a victim of trafficking, and I am challenging the legislation as discriminating against the class to which I belong. So that's why Section 7 entitles somebody who is a victim or would be a victim to bring a challenge under the Human Rights Act. I am a victim because I'm a victim of trafficking, and it is discriminating against victims of trafficking as a class. So that is why.
But surely you have to show that you're a victim who would, if the violation were established, be able to claim.
No, if the violation that I need to establish is that this legislation is incompatible on its face with Article 4 in conjunction with Article 14, and has therefore to be read in a different way that renders it compatible. That is what I'm a victim of, and that is what I have to establish. Not what the consequence would then be of my particular application. That's an entirely different matter. I am challenging this legislation as a victim of trafficking on the basis it discriminates against me as a class. So that's why in my submission, victims of trafficking are a distinct group. Can I turn very quickly to the Court of Appeal's answer to this, and as to why it concluded victims of trafficking didn't need to be dealt with in a different way? And that's set out at paragraph 95 of its judgment at page 190. And it said at 95, insofar as their situations are significantly different, victims of trafficking are treated differently from others who commit crimes resulting in custodial or community sentences. And it then identifies the domestic non-punishment framework provisions. That is, the provisions introduced in English legislation and prosecutorial discretions, whereby effect is given to that duty to ensure that individuals with nexus offences are not prosecuted. And it then goes on to say this at the end of the paragraph. If, however, a victim of trafficking is for some reason unable to benefit from any of these protections, then the circumstances of the offending would likely be so divorced from the trafficking as to point him or her to him or her not being a blameless victim of a crime of violence. Now, we have answered that in our case. The Court of Appeal was, in our submission, factually wrong about that. It had before it submissions and evidence identifying that not everybody who is a victim of trafficking, even with a nexus offence, will be able to avail themselves of the non-punishment provisions. And included in that, for example, are individuals whose convictions are imposed by a foreign court. So, for example, they were trafficked initially in a foreign country, then trafficked over to the United Kingdom. They cannot avail themselves of the United Kingdom provisions, and it's not clear at all that they will be able to have those convictions overturned in the countries from which they came. But we give other examples of that, and those are detailed in our case, and I just want to give you the references for that. It's dealt with in detail by the interveners in paragraphs 29 to 35 of their case at EB 152.
Sorry, paragraphs again?
29 to 35, EB 152. More briefly, but to the same effect in our case at EB 96, paragraphs 128 to 130. It was raised before the Court of Appeal in our skeleton before the Court of Appeal at paragraph 39 EB 425. And in our submission, it is simply wrong. And if we're right about that, if the cases we've identified mean that there will still be blameless victims of trafficking caught by paragraph 3 and thereby excluded from applying under the scheme, then in our submission, the difference in treatment, or the failure rather to treat them differently, does fall to be justified. The respondent has one answer to that, which I'll deal with very quickly. It's at paragraph 78 of their case at page 125, where they say that as the High Court and the Court of Appeal held, there is nothing in EU law that requires victims of trafficking to be treated more favourably than other victims of crime. And that's absolutely right. I haven't said that there is. Our case is that the Convention and Article 4, together with Article 14, for the reasons I've given, requires requires victims of trafficking because of their special circumstances to be treated differently. And I then come to justification, and I'm sorry for the unbelievable rate at which I'm whizzing through this, but there is quite a lot to get through. We've put our case on the basis that the Supreme Court's decision in DA and the Secretary of State for Work and Pensions applies. That is, that the sole test and the sole question of justification is whether or not the measure is manifestly without reasonable foundation. I know, and as I understand it, Lord Stevens was involved in this hearing, that SC and the Secretary of State for Work and Pensions was heard on the 20th and 21st of October, in which it was argued that because of a case from Strasbourg, JD and A, the Supreme Court should reconsider DA for itself. And needless to say, if the Supreme Court does that and concludes that actually the test is a more stringent one than manifestly without reasonable foundation, then we submit that test should be applied in this case. But for the present purposes, we proceed on the basis that the test is manifestly without reasonable foundation. Relevant paragraphs are paragraphs 65 and 66. I'm simply going to make the point, rather than taking your lordships to that even with such a loose test, Lord Wilson makes absolutely clear that the court must carry out a detailed and careful assessment of the justification put forward. And it must look at whether or not it pursues a legitimate aim and so forth, all the 4 questions that one has to ask. But some very helpful in my submission guidance has been given by the Court of Appeal by Lord Justice Leggett, as he then was, on how you approach the proportionality aspect of the justification assessment, where one is applying the manifestly without reasonable test.
This is the Court of Appeal decision that was appealed in SC.
It's exactly that, yes. It's the Court of Appeal decision appealed in SC, and that's at page 2275. And it's the SC case, and if you go to page 2303.
Sorry, 2303?
2303. And to paragraphs 88 and 89. So you can see from 88, he's applying the manifestly without reasonable foundation test. And at 89, he says this: although it's not immediately obvious how the manifestly without reasonable foundation test relates to the assessment of proportionality that the court must undertake, the explanation may be that the court is required to ask whether the difference in treatment is manifestly disproportionate to a legitimate aim. And that would accord with the statement of the European Court in Blecic, and so forth. And then, also for our purposes, he looks at the intensity of the review at paragraphs 90, 91, 92, and 93. And relevant are how within those concentric circles, how far within them the particular status falls. So if you're in forbidden territory of race or sex, then there is going to be a relatively greater intensity of review than if your status is something much, much looser and less personal.
And where do you
then
say
it's-
that the case of a victim of trafficking falls within the concentric circles?
We don't say that we are in the centre of the concentric circle, no, but we also don't say that we are in the acquired planning permission by virtue of an order of the court or whatever it was. You know, we are somewhere.
Somewhere in the middle.
We're somewhere in the middle, yes.
Thank you.
Second relevant consideration at 92 is whether or not the measure has been approved by Parliament. We'll come to that very, very briefly. I'm not quite sure how. Then it's the extent of 93, the values and interests relevant to the assessment of proportionality were actually considered when the policy choice was made. So can I just, for your lordships, Pens and my lady, note that that approach by Lord Justice Leggett was approved by the Court of Appeal in Langford, and this is all in our case, and also in the JCWI case. So the first question then is, does it pursue a legitimate aim? Now, we saw in Flimenos that the legitimate aim is focused upon the failure to treat the individual differently. Is there a legitimate aim being pursued by not treating victims of trafficking differently from other victims of crime fought by the paragraph 3? And A and the the Secretary of State for the Home Department, which is a Supreme Court authority, tab 23, 1020, is another authority that is the right approach. Can I simply give, for your lordship and my ladyship, note the relevant paragraphs? So paragraph 68 in the judgment of Lord Bingham, page 1076. Lord Nichols agreed at 85, page 1081. Lord Carswell agreed at 240, paragraph 240, page 1127. And Baroness Hale at page 234, sorry, paragraph 234, page 1126, made precisely the same observation. She tried to find the legitimate aim pursued by the failure or by the discrimination itself, not by the overarching measure. So what's the legitimate aim? That the discrimination, the failure to treat the victims of trafficking differently pursues. The only possible legitimate aim identified by the Court of Appeal was at paragraph 97 of its judgment. So you may still have, you won't still, if you can go back to page 190. And we can see at at 96, they make the point that we I'm sorry, my lords, I'm just trying to see whether I've got to take you to 96. Yes, so 96 was looking at our particular circumstances, saying, well, they don't apply to you, and I've dealt with that. We're talking about the class of victims of trafficking. And then at 97, they come to this. Thirdly, it's necessary to confront the appellant's criticism that the scheme, based on the exclusionary rule, not leaving a claims officer with discretion, as was the case under previous versions, is the blunt answer is that the national states are allowed a margin of appreciation in this area, are free to draw lines. So it's the bright line justification, and they refer to Lord Neuberger in RJM. Drawing a line does not of itself mean that the policy was manifestly without reasonable foundation. Or put it another way, as the judge observed, the building in of discretion is necessary for the policy to have a reasonable foundation. Parliament approved the provisions, and we'll come to parliamentary approval in a moment. So that is the justification that is offered. So we need to look at whether or not having a bright line is a justification in this case that is not manifestly disproportionate. And the case we need to look at is Brewster. Brewster is at page 1313, paragraph 28. And the relevant paragraph is in the judgment of Lord Kerr, and Lord Kerr gave judgment for the court. We can see that at page 1316. And then if we go to paragraph 56 on page 1331. So there was heavy reliance on the joint dissenting judgment of Lord Sumption and Lord Reed in the Tigere case. And if you then go down to just below F, 2 lines below F, halfway along the line, the judgment was also cited in support of the bright line rule that the nomination procedure is said to establish, and in advancing the case that in the socio-economic field, a broad area of discretionary judgment should be allowed to state authority. These principles, well recognised as they are, depend heavily on the context in which it is sought to apply them. As it happens, I have no difficulty in accepting that each is worthy of close consideration in this case, but whether they impel the outcome for which the respondents contend must be subject to careful examination of the particular aspects of the case which they are said to affect. And I've asked the court to note that. And then paragraph 60 through to paragraph 62. So looking at a comparison between the Tigere case and this case, and recognising one has to focus on the particular circumstances and context, the differences could not be greater. There was clear legitimacy in recognising administrative convenience in the Tigere case. It was a very, very large-scale scheme which had to be applied quickly to a large number of different individuals, and therefore have an easy mechanism by which to make selections, obviously had significant weight and was an important value. There is no evidence whatsoever that this scheme, and paragraph 3 in particular, was pursued for administrative convenience. The justification put forward was that it is proportionate to have a proxy for blameworthiness in order to ensure that the scheme is properly targeted at those it is intended to benefit. Well, insofar as it is possible to identify a group of individuals who are special, and even though they have spent convictions may not be blameworthy, there is nothing contrary to the intention of the scheme in bringing them out of the exclusion. On the contrary, it furthers the purposes of the scheme by making sure they have the opportunity, if they are blameworthy, from benefiting. There is no administrative inconvenience by offering them that avenue because, and this is absolutely critical in terms of the further distinction, this is not a scheme that operates by reference to bright line rules. It is a scheme that allows for discretion. That's what paragraph 4 does. And that all one needs to do is to transfer an identifiable class who can be easily and readily identified, and they're already identified by reference to paragraphs 10C through 13 through to 16, and make sure that they are excluded from paragraph 3 and included in paragraph D. It's all that you need to do. And it is submitted that given that including them furthers the purpose of the scheme, so very clearly because of the particular group that they are, given also that the scheme doesn't mean that those who are not blameworthy will get through, they won't, and given further that many individuals will hopefully benefit from the non-punishment provisions, we are talking in all probability about a relatively small number of individuals who are going to be removed from the non-discretionary into the discretionary. And in our submission, it is manifestly disproportionate on the basis of a bright line rule that is not actually pursuing anything meaningful at all, other than it's what the government has chosen as being the proxy for blameworthiness, manifestly disproportionate not to remove this particular sub. I would ask the court's indulgence that I just finish my submissions and, if necessary, break into my reply and reduce the time on that. If
well, you are now past your time limit, Ms. Kaufman. How much longer do you want to continue?
Very short. A few more minutes.
I mean, we have your written submissions. You only have 20 minutes for a reply anyway.
Yes, I've got a few more minutes. That's it. Just a couple of minutes.
Right.
I just want to complete by dealing with what the Court of Appeals said at paragraph 98. If the court's still there, it's page 190. As part of the finding that the scheme was justified, it focused on the way in which the scheme is nuanced. Page 190. Everything there identified has nothing to do with victims of trafficking caught by paragraph 3. It does nothing to justify their exclusion. And in my submission provides no justification whatsoever for the failure to treat them differently. That's the very short point on that. On parliamentary scrutiny, which is plainly a matter for the court to give weight to in terms of how intensively it scrutinises, it's important to say that there was no parliamentary scrutiny whatsoever of this discriminatory measure. Whilst the Parliament did scrutinise the scheme overall, it did not have any regard to its discriminatory impact in paragraph 3. So in our submission, that necessarily entails that the court need not defer to Parliament in the way that it would understandably and properly if there had been full scrutiny and justification offered of why the measure was doing what it was doing. And finally, on relief, my lords, I've communicated to Mr. Collins yesterday the way in which I would like to put the relief slightly differently to how we put it in our case. And if I could just indicate to the court, and we can provide this in writing afterwards.
I'd be grateful if you would, yes.
Yes, what we'd ask by way of relief. So just running through it very quickly, what we would actually seek by way of relief is a rereading of the scheme, and specifically paragraph 3 of Annex D, in accordance with the interpretive obligation under Section 3 of the Human Rights Act. And that's something that was highlighted by ATLEU in their case, and I've subsequently thought about it, and I think that is right. That's perfectly possible and permissible. The interpretive obligation is, or what it entails, is identified at paragraph 96 of, for example, the Smith and Lancashire Teaching Hospitals case at EB 2360. The relevant paragraph is paragraph 96. Sorry, reach the page. 2387. Yes, 2387. At paragraph 96 It's not in dispute, and in accordance with the guidance and speeches from Guyden, a declaration of incompatibility under Section 4 is a last resort and should only be made when it is impossible to interpret the provisions in question in such a way as to make it convention compliant. Also clear from Guyden and other cases that the interpretive power under Section 3 is very wide and can require a court to read in words which change the meaning of enacted legislation. The only limitation are that the court cannot adopt a meaning which goes against the grain of the legislation, that is to say, that is inconsistent with a fundamental feature of the legislation, and the court cannot make decisions for which they are not equipped. Now, applying that, if one reads in the words at the beginning of paragraph 3, and it's worth pulling it up briefly, of the scheme, which is at page 554. What you would do in our submission to achieve compliance is at the beginning of paragraph 3, you would write in, or read in, save where the applicant is a victim of trafficking, in which case paragraph 4 will apply. And then an award will not be made to an applicant. So save where the applicant is a victim of trafficking, in which case paragraph 4 will apply, and that remedies the problem. So we would seek a declaration that pursuant to section 33 of the HRA, and as I said, we will provide this in writing, paragraph 3 of Annex D of the Criminal Injuries Compensation Scheme shall be read and given effect by reading in the following words at the start of the paragraph.
Right. You can let us have that in writing, Ms. Kaufman.
And then we would also seek an order that our applications be reconsidered in accordance with the scheme, interpreted in light of the declaration at paragraph 1. And we will provide that in writing.
Thank you. Thank you very much. Mr. Collins.
I apologise.
Not at all. There's a lot of ground to cover in this case. I've been very mindful of that. Mr. Collins, you've got a few minutes before lunch. I think probably better to start and to use that time.
My lord, yes, of course. And that may well work well, because what I wanted to do was, before getting into the detail of my submissions, just set out a small number of preliminary points which we're going to ask the court to bear in mind when considering the issues in the case. Some of the points I'm going to make may seem, in some respects, obvious, but they, we say, nonetheless important, and they set the context for the submissions that I'll make this afternoon. And there are, I think, 8 points that I wanted to make, and I think I can do them in the 5 minutes before lunch. The first is this, that the Criminal Injuries Compensation Scheme is a taxpayer-funded scheme whose purpose is to make payments to those who have sustained injury as a direct consequence of a crime of violence. Secondly, the scheme is a creation of primary and secondary legislation. The terms of the scheme are set by the government in accordance with powers contained in the Criminal Injuries Compensation Act 1995 and are approved by Parliament. Thirdly, the scheme does not pay compensation to every victim of every crime. The key limitations are that it pays only to those who have sustained injury, and only where that injury is sustained as a direct consequence of a crime of violence. Just to correct in that context something my learned friend said this morning, she submitted that these appellants would, were it not for the provisions in issue here, have met the terms of the scheme. We don't know that one way or the other. As the Court of Appeal noted, because the threshold condition wasn't met, the claims officer didn't go on to examine whether they would have met the terms of the scheme in other respects. The fourth point is this, that applicants to the scheme may, of course, be victims of trafficking. The scheme is open to them, and the complaint which these appellants made below of a failure to comply with the requirements of the directive, which requires that victims of trafficking have access to domestic schemes for compensation, that failed, and permission to appeal to this court was refused. So victims have access to the scheme, But of course, most applicants are not victims of trafficking. The scheme we submit is not intended as the basis upon which victims of trafficking are supported in the UK. Fifth, we say that payments under the scheme have been described as being made out of a recognition of a sense of public sympathy for the pain and suffering of the victim. Sixth, it is internationally recognised as appropriate to exclude those with a history of criminality from state compensation schemes of this sort. Seventh, there is a regime to protect victims of trafficking from criminal sanction. Now, of course, individuals may be wrongly convicted under the best devised and best run regime, be they victims of trafficking or not, but individual failures cannot make the regime itself inappropriate or unlawful. And then eighth, and finally, so far as these preliminary points are concerned, as the court has already noted, these appellants' offences are unrelated to their having subsequently become victims of trafficking. They were trafficked after they were convicted and after they had served their sentences. So their convictions were not caused by trafficking. My lords, my lady, those were the preliminary points I wanted to start with. With 2 minutes to 1 o'clock, it may not make sense for me then to launch into the beginning of my submissions on Ambit, which of course is where I'm going to start.
Right. We'll adjourn now, Mr. Collins, and we'll sit again at 2 o'clock.
My lord, can I ask, just for the purposes of my planning, having had sort of lost 10 minutes, as it were, this morning, can I carry on 10 minutes longer this afternoon?
Yes, you can. You were due to finish at 3:40.
Yes.
And you can continue until 3:50.
I'm very grateful.
That will allow just 10 minutes, I'm afraid, Ms. Kaufman. But there's a lot of ground. There's a lot of ground to cover in this case. And on reflection, it may be that the time estimate was an underestimate. But there it is. We've got to do the best we can in the time available. We do have the benefit of the very full submissions that you both put in, for which we're very grateful.
Oh, yes.
Thank you very much. 2 o'clock.